Welcome guys, this is last part of this series. Let's begin. Our first question is, what is alimony pendant light as defined under section 36 of chapter 7 of the Special Marriage Act 1954? How does this section address the financial support of a spouse during divorce proceedings? Alimony pendant light is a form of temporary financial support granted to a spouse during the ongoing divorce or legal separation proceedings. The term pendant light is a Latin for pending the litigation, and it signifies that the alimony is intended to cover the spouse's financial needs while the legal case is being resolved. Under Section 36 of Chapter 7 of the Special Marriage Act 1954, the provisions for alimony pendant light are as follows. Provision for financial support. Eligibility. If, during divorce or legal separation proceedings, the court finds that the wife lacks sufficient independent income to support herself and cover the necessary expenses of the case, it can order the husband to provide financial assistance. This support is designed to ensure that the wife can maintain a reasonable standard of living while the legal proceedings are ongoing. Amount and duration. The court determines the amount of the alimony based on the husband's income and the wife's financial needs. The support is typically provided on a weekly or monthly basis throughout the duration of the proceedings. Timeline is resolution of application. The application for alimony pendant light must be addressed within 60 days from the date of service of notice on the husband. This ensures that the financial support is provided in a timely manner, minimizing delays in addressing the spouse's needs during the proceedings. Case laws. K.K. Verma versus M.K. Verma. Fact of this case, the Supreme Court dealt with issues related to the adequacy of alimony pendant light. Judgment. The court confirmed that alimony pendant light is intended to prevent financial hardship for the spouse who is economically disadvantaged during divorce proceedings. The support amount should be fair and proportional to the paying spouse's financial capacity. Next case, Srimati Manju S. Verma versus Ashok Kumar Verma. Fact of this case, the case involved a review of the alimony pendant light ordered by the lower court. Judgment. The Supreme Court emphasized that the amount of alimony pendant light should adequately reflect both the financial needs of the receiving spouse and the paying spouse's ability to provide support. It is essential to ensure that the spouse seeking support can sustain themselves reasonably until the conclusion of the legal proceedings. Our next question is, what provisions are made under Section 37 of the Chapter 7 of the Special Marriage Act 1954 regarding permanent alimony and maintenance? How does this section address modification based on changes in circumstances or the remarriage of the receiving spouse? Permanent alimony and maintenance refers to financial support ordered by court to provide for the long-term financial needs of a spouse following a divorce or annulment. This support is typically granted to ensure that the receiving spouse can maintain a reasonable standard of living. Section 37 of the Chapter 7 of the Special Marriage Act 1954 provides the following provisions for permanent alimony and maintenance. Provision for permanent alimony. Order for maintenance. The court may order husband to provide a gross sum or periodic payment, such as a monthly or otherwise, for the wife's maintenance and support. This order can be made at the time of passing a decree or subsequently. The amount is determined considering the wife's property, the husband's ability to pay, and other relevant circumstances. Securing the payment. The court may require that the maintenance be secured by a charge on the husband's property. if necessary. The provision ensures that the financial support is reliable and enforceable. Modification of the alimony, change in circumstances. The court has the authority to vary, modify, or rescind the maintenance order if there is a change in the circumstances of the either party after the initial order. This flexibility ensures that the support remains fair and relevant to the parties' current situations. Impact of the remarriage or misconduct. Remarriage or misconduct. If the wife receiving the alimony remarries or is found not leading a chaste life, the court may, at the husband's request, modify or rescind the maintenance orders. This reflects the principle that significant personal changes can impact the necessity and fairness of the continued support. Case laws: V. Venkatesh versus Srimati Meenakshi. Fact of this case: the case involved a challenge to amount of alimony awarded, considering the husband's financial status and the wife's needs. Judgment: the Supreme Court emphasized that alimony should be reasonable and reflect the actual needs of the receiving spouse, while considering the paying spouse's financial capacity. The case underscored the court's role in balancing these interests. Next case: Srimati Rukmani versus Venkatesh. Fact of this case: the case addressed the issue of modifying alimony following the remarriage of the wife. Judgment: the Supreme Court upheld that the remarriage of the receiving spouse is a valid ground for modifying or rescinding alimony orders. The court confirmed that personal changes such as a remarriage could affect the need for the continued financial support. Our next question is: what provision does Section 38 of the Chapter 7 of the Special Marriage Act 1954 make regarding the custody, maintenance, and education of the minor children during the after proceedings for divorce or judicial separation? How does the section ensure that the interests of the minor children are addressed? Section 38 of the Chapter 7 of the Patient Marriage Act 1954 focuses on the custody, maintenance, and education of the minor children in the context of divorce or judicial separation proceedings. Here's how it addresses these aspects: custody, maintenance, and education. Interim orders. During the proceedings under Chapter 5, restitution of the conjugal rights and judicial separation, or Chapter 6, nullity of the marriage and divorce, the district court is empowered to issue interim orders concerning the custody, maintenance, and education of minor children. These orders are intended to provide temporary arrangements and ensure the children's needs are met while the case is ongoing. Provisions in the decree. The final decree may include specific provisions related to the custody, maintenance, and education of the minor children. These provisions are designed to be just and proper, taking into account the children's welfare and, where possible, their wishes. Post-decree modifications, ongoing adjustments. After the decree is issued, the court retains the authority to make, revoke, suspend, or vary orders regarding the custody, maintenance, and education of the children. This means that even after the final order, adjustment can be made if circumstances change or if the need of the children evolve. Timeliness of the decision. Expedited applications. The section stipulates that applications related to the maintenance and the education of the minor children during the proceedings should be disposed of as expeditiously as possible, ideally within 60 days from the date of the service of the notice on the respondent. This provision ensures that the decisions affecting the children's well-being are made promptly to avoid unnecessary delays. Case laws. Srimati DB versus Mrs. SB. Fact of this case involved a dispute over the custody of minor children following a divorce. Judgment. The Supreme Court upheld the principle that the welfare of the children should be the paramount consideration in the custody decisions. The court highlighted that the wishes of the children should be considered wherever possible but must be balanced against their overall well-being. Next case, AS versus SR. Fact of this case, the case dealt with the modification of the custody arrangement after the final decree. Judgment, the Supreme Court affirmed that the court has the authority to modify custody orders if circumstances changes significantly. The court emphasized that the adjustment should be made to ensure that the children's needs are continually met and their best interests are protected. Our next question is, what are the provisions regarding appeals, enforcement, and procedural aspects under the Special Marriage Act 1954 as outlined in the Section 39 to 41 of the Chapter 7? Section 39 to 41 of the Chapter 7 of the Special Marriage Act 1954 cover important procedural aspects related to appeals, enforcement of decrees, and application of general procedure rules. Here's a detailed explanation of each section. Section 39. Appeals from decree and orders. Appealability of decrees and orders. Decrees. All decrees made by the court in proceedings under Chapter 5, restitution of conjugal right and the judicial separation, or Chapter 6, nullity of marriage and divorce, are appealable. Appeals can be made to the court where appeals from the original civil jurisdiction are ordinarily heard. Orders. Orders made under Section 37, permanent alimony and maintenance, or Section 38, custody of children, are appealable if they are not interim orders. These appeals also lie to the court that hears appeals from the original jurisdiction. Exclusions. There is no appeal on the subject of cost only. Timeline. Appeals must be filed within 90 days from the date of the decree or order. Appeal procedure. Appeals are to be treated similarly to appeal from the decree in the exercise of the original civil jurisdiction, ensuring a uniform process for the challenging court's decisions. Section 39A. Enforcement of decree and orders. Enforcement of mechanism. Decrees and orders made under Chapter 5 or Chapter 6 are to be enforced in the same manner as decrees and orders of the court made in the original civil jurisdiction. This ensures that the implementation of the court order follows established civil enforcement procedures. Section 40. Application of the Code of Civil Procedure 1908. Regulation by Code. Proceedings under this Act are regulated by the Code of Civil Procedure 1908 (CPC) as far as possible. This includes adhering to the procedural rules and practice outlined in the CPC, with specific rules made by the High Court as needed. Section 40A. Power to transfer petitions in certain cases. Transfer of petitions. Simultaneous petitions. When one party files a petition for judicial separation or divorce and the other party subsequently files a similar petition, whether in the same or different district court, the court handling the latter petition must transfer it to the court where the earlier petition was filed. Handling. The petitions are to be tried and heard together by the court that received the earlier petition. Transfer procedure. Transfer authority. The competent authority under the CPC is responsible for the transferring the later petition to the earlier court to ensure both petitions are dealt with together, promoting efficiency and consistency in handling related cases. Section 40B. Special provisions related to trial and disposal of the petitions. Trial continuity. Day-to-day trial. The trial of the petitions under this Act should, as far as practicable, continue daily until conclusion unless adjournment is necessary for recorded sessions. Expedited process. Trial and appeals. Effort should be made to conclude trials within 6 months from the date of the notice service on the respondent and to finalize appeals within 3 months from the notice of the appeal. Section 40C. Documentary evidence. Admissibility. Documents are not to be excluded from evidence solely on the grounds of being unstamped or unregistered. This provision ensures that the relevant evidence is considered regardless of the technical deficiencies in the document formalities. Section 41. Power of High Court to make the rules regulating procedure. Rule-making authority. The High Court is empowered to make rules for the effective implementation of the Chapter 5, 6, and 7 of the Act in alignment with the CPC. Specific rule provisions, impleading and damages. Rules include provisions for the impleading an adulterer as a co-respondent in divorce cases based on adultery, awarding damages, and the intervention of the additional parties in proceedings. Petition details. The rules, which also address the form and content of the petitions, payment of costs, and any other additional matters covered under the Indian Divorce Act 1869.